This court is resumed. Please be seated.
Just as a point of housekeeping, it's going to be my intention to go, subject to the court's direction, of course, to go to around 3:15, take a little break, and then go till 4:30.
Thank you.
Before the lunch break, the court asked a question about, the 30% indirect. Where does it come from other than taxes? The answer is in the evidence. As far as I know, there's only a reference to it coming from taxes, and that principally it's income taxes and corporate and personal income taxes. But I can conceive, because of the example I'm going to give you, that it could theoretically be sales tax or GST as well, but taxes. And the example I give right now, I think might help explain it. Suppose the government has some trees that has a resource rental value of 100 units, $100, $100,000, 100 units. The government decides, we'd like to give out some corporate welfare today. We'd like to sell that tree for $10 or 10 units. So the Crown has direct 10 units, $10 in direct revenues, and it's made a policy decision to forego $90 of revenue or 90 units of revenue that it should have and could have captured if it was able to capture the full value of the resource rent. Well, the timber company finishes the year and they look at their balance sheet and they say, gosh, it's been a good year. We made an extra 90 units, an extra $90. So what happens is they pay income tax on the extra $90. And when they pay the taxes, the government effectively recaptures around 30% of that $90, which is in effect recapturing a portion of what is really resource rent. So that is the explanation of the source of the 30% indirect recapture. Any questions on that? Okay. As recaptured indirectly, yes. So I wanted to turn now to the witnesses. The court has a difficult task of going through and assessing the credibility of the witnesses, and I thought I might take a little time to give the court my impressions of how the witnesses fared. And I wanted to start with the plaintiff's witnesses. I don't know if the court has a question. Yeah.
Yes, I see that recollecting some historical facts was next.
I've got it out of order, do I?
I'm quite content if you follow.
Yeah, I switched the order at the last moment.
Okay.
Yeah.
Very good. Thank you.
Thank you for taking that, bringing me to that. So the plaintiff's witnesses. First, Professor Joseph Stiglitz, economist. Professor Stiglitz is a Nobel Prize-winning, world-renowned economist who testified about the methodology behind using an economic rent model to quantify what the Anishinaabe brought to the table in 1850. He also provided an economic interpretation of the sharing required under the treaty and provided guidance on the methodology behind quantifying relative wealth and needs and how past amounts should be brought forward. Professor Stiglitz was both credible and reliable. My observation is that Professor Stiglitz did not just testify, he communicated ideas and opinions with clarity and with a deep understanding of the issues. all the while staying true to principles of respect, responsibility, reciprocity, and renewal, and ultimately putting forward a model that is both fair and just. I perceived his testimony to be balanced, thoughtful, insightful, and ultimately conservative, erring on the side of reducing rather than inflating the likely quantum of losses. I also observed that little of what he opined on was sought to be challenged on cross-examination, and no part of his testimony, we say, was undermined. Now, although the defendant's experts have raised objections to utilizing the rent model as a basis of compensation in this case, Stiglitz and Hutchins responded to those concerns and complaints in their reply report, Exhibit 4, and they were not significantly or substantially raised with Stiglitz or Hutchins on cross-exam. In respect of Professor Stiglitz's cross-exam, much of it was focused on the calculation of NCRRs, net crown resource revenues. For example, Canada focused substantially on the appropriateness of including spectrum. There was actually very little cross-examination of Stiglitz and Hutchins on rents. Second witness, Mr. David Hutchins.
I just ask you to slow
Yeah.
down a bit. I
Oh, yes, I'm sorry.
probably reading, but
Yeah, yes, I am probably reading a portion of it anyways. Okay, Mr. Hutchins, economist. Mr. Hutchins is an economist who carefully and thoughtfully applied the resource rent methodology articulated by Professor Stiglitz to conservatively estimate the resource rents in the treaty territory from 1850 to 2019, as well as estimating the net direct crown resource-related revenues, the direct NCRRs. He brought his experience and expertise to bear on calculating the relative wealth and needs assessment, the income gap, and he performed numerous bring forward calculations. Now, contrary to Ontario's argument, it is not the case that Mr. Hutchins lacks experience in dealing with public accounts. Relying on a series of questions put to Mr. Hutchins in cross-examination at transcript page 1513, Ontario argues at para 178 of their submissions that Mr. Hutchins has, and this is in quotation marks, never worked on a public account, close quotation marks. Respectfully, that is not what the evidence was. And even if it were true, this is no basis to diminish the quality and compellability of Mr. Hutchins' evidence. Mr. Hutchins, in fact, was not asked whether he had worked on a public account. He was asked whether he had worked on the preparation of the public accounts of Ontario. He replied, no, but then did confirm that he had worked for government, although not as an employee. Moreover, a brief perusal of Mr. Hutchins' resume, which I'm not going to take you through, substantiates his expertise in core matters of concern for this court. His real-world experience in assisting courts with valuation and public policy issues, and his expertise in economics and mathematics was on display for all to see when he took the stand. His knowledge and experience and his command of the economic data was, in a word, unparalleled in this case. Although that's 4 words, I'll stick with unparalleled. It is simply unfair to suggest there is a basis to doubt the helpfulness of his testimony. Mr. Hutchings was credible. His opinions and conclusions and analysis were reliable, and he was precise in his comments. He demonstrated a deep understanding of an incredible recall with respect to not just his own reports, his own work papers, his own calculations, but also of the other experts as well. Mr. Hutchings was able to testify to numerous errors in the work papers of other experts. Time and time again, he found errors in Bodway and Smart's data entry, in their calculations, in their methodology. You might recall that Professor Smart at first rejected such complaints, describing them as being categorically incorrect, or alleging that Mr. Hutchings simply failed to understand their code. But they came to realize, and later admit on the stand, sometimes only on the stand, sometimes before they took the stand, that it was they, Bodway and Smart, who were in error. Like Professor Stiglitz, Hutchings' methodology and his calculations were not challenged to any significant extent. And when challenged on cross-examinations, his opinions and calculations withstood scrutiny. His calculations should be preferred to those of any other expert. Dr. Dribbin, ethnohistorian. Dr. Dribbin is an ethnohistorian whose testimony assisted the court in stage 1. Dr. Dribbin has over 40 years of observing and living among the Anishinaabe people in the field. Dr. Dribbin demonstrated a deep understanding of the culture and the perspectives of the Anishinaabe people that simply cannot be found by reading the books of others. Dr. Dribbin testified with clarity as to the Anishinaabe understandings of the augmentation clause and the importance of kinship and reciprocity and the importance that those concepts continue to have. He brought forth an ethnohistorian's understanding of Mino-Bamadzuin, the good life. Now, not one to exceed that which he legitimately could opine on, Dr. Dribbin was frank that he could not, and he did not, attempt to answer the question as to what monetary share would be needed to support the quest for Mino-Bamadzuin today. Instead, he provided some guiding principles, such as explaining that Mino-Bamadzuin means more than just a moderate standard of living, and that it is the search for the best life possible. His report, the second report, and his testimony as to the slow growth rate for Anishinaabe and their likely true populations from time to time, and his opinions on population levels was essentially corroborated by the independent work done by Dr. Bignami, which brings us to Dr. Bignami. Dr. Simona Bignami is a demographer from the University of Montreal, I believe. She employed her specialty in Indigenous demography for the court. Dr. Bignami presented her population estimates of the Indian bands who have resided within the Robinson Superior Treaty Territory since 1850. She was confident and knowledgeable, and her low and high growth population estimates were not successfully challenged. Moreover, her conclusions were independently supported by the independent views expressed by Dr. Driven. Turning to the lay witnesses, the first person we had that I want to speak of is Elder Marcel Donio. Elder Marcel Donio is a member of the Bingui Nayashi Anishinaabe, formerly known as Sandpoint First Nation. They're a group of 7 First Nation. Elder Donio provided the court with a very passionate and very thorough explanation of the importance of the clan system, the 7 grandfather teachings, and the importance of the land to Anishinaabe people. Chief Duncan Mashano also testified. Chief Mashano is the chief of Bictagong Anishinaabe, also a group of 7 First Nation. He spoke eloquently about the dramatic lower standards of living on reserve that he has historically experienced as compared to the communities at Heron Bay, South, and Terrace Bay. He also testified quite passionately as to the Anishinaabe people's deep connection to the land and water. Remember, nothing is more valuable, he said. And he explained how Bemadzewin is a commonly held Anishinaabe principle that unifies the First Nations in the Robinson Superior Treaty area. I think it's fair to describe his testimony as passionate and articulate in expressing that Bemadzewin does not simply entail a subsistence living, but that it requires resources to ensure the good health and prosperity for 7 generations. Next witness, Elder Raymond Goodchild. Elder Raymond Goodchild is a member of the Pays Plat First Nation, a group of 7 First Nation. Elder Goodchild gave what can only be described as a heart-wrenching account of the severe deprivations he suffered as a child growing up on reserve, all the while witnessing industry, forestry, pulp and paper, hydroelectricity, profiting off the land, and those employed by industry living in far better conditions on the land adjacent to reserve. He discussed his family's poverty and the need to go into garbage bins to find sustenance to eat. He came across as honest, candid, and helpful in providing the court with a picture of the generational poverty that he and his family and others have experienced. His experience in life, I believe he said, is sadly one that is shared not just by him, but by many others. It was surprising to me that through it all, he was able to smile and stay positive, but he came across as a positive witness, and I think we owe him a debt of gratitude for his candor. Chief Patricia Tangi testified. Chief Tangi is the chief of Michipicoten First Nation, one of the group of 5. She spoke eloquently about Anishinaabe people's respect for the lands and waters and the elements one needs in pursuit of Minnow Bemadzewin. She explained that the principles and values of Minnow Bemadzewin have been the same since the beginning of time, and that what changes over time are the things needed to walk the path of Bemadzewin. She meaningfully spoke of her ancestors saving and investing for future generations in the lands and resources prior to human contact, prior to European contact, and spoke passionately and convincingly of the responsibility that Anishinaabe people embrace to ensure that the wealth of the lands and the resources are used in a manner that will permit the Anishinaabe people to thrive, not just now, but into the future. Chief Tangi also spoke of the professional advisors that the First Nation has hired over the years to assist the First Nation when they are dealing in matters beyond their understanding. Examples she gave were hydrology and ecosystem experts and professional financial and investment advisors. She was heartfelt and genuine as she discussed Anishinaabem's people resilience and her vision for an independent, strong, and prosperous future. Councillor Michelle Solomon, now Chief Solomon. Former Councillor Solomon is a member of the Fort William First Nation, a group of 5 First Nation members, since elected to be the chief. She testified to her upbringing on reserve and the substandard living conditions she and other Fort William members experienced. She testified that Bemadzwen means thriving, not just surviving. And she explained in detail how Fort William had hired trust managers and financial advisors to help them save and invest for the future, to work towards Bemadzwen. She also testified that Fort William has a mixed portfolio of high and low risk investments. She was trustworthy, well-spoken, and like all lay witnesses from the plaintiffs that took the stand, was credible and reliable and believable. Chief King. Chief Wilfred King is the chief of the Gull Bay First Nation, a group of 5 First Nation. Chief King recalled the frustration amongst Gull Bay community members that the Robinson Superior Treaty has never been fully implemented as it should have been. And he discussed his and his ancestors' understanding that there was supposed to be a sharing of the resources under the treaty, and that to date, this has not happened. Chief King also testified about how the core of Bemadzwen has not changed since 1850. He explained that it was the best possible thriving life, and at the very least must be commensurate with what other Canadians enjoy. He explained the need and the use for compensation in this case to assist in the pursuit of Bemadzwen. Chief King was authentic, sincere, truthful, compelling in his evidence, and credible and reliable. That was the case for the plaintiffs. Canada's experts, and I might say these are just observations from me listening to what the witnesses said. It's not intended to be a complete recitation of everything they testified to. And Canada's experts. First, there was Professor Jack Mintz, an economist. Professor Mintz testified principally to the issues regarding spectrum and logging tax revenues. He did not deal with Ontario's revenues to any great extent, as he was asked only to deal with Canada's revenues and expenses. My view of it is he presented it as a friendly and cooperative witness who unfortunately was obviously fairly unfamiliar with the historical record and the evidence of what had taken place. My notes were that he was at times forgetful and at times deferred to Mr. O'Riordan on a number of matters, including whether reciprocity was factored into their analysis, and we learned that it was not, and how Mintz and O'Riordan considered the parties' shared goals, expectations, and understandings in 1850. His position on spectrum, that spectrum is unrelated to geography, was shown to be in error, as were other aspects of his opinions. Missing from his opinion was any rational, logical, or defensible connection to the shared goals, expectations, and understandings of the parties and the Anishinaabe principles that animated the treaty. Here, I want to stop for a moment and remind the court that the stage one reasons at paragraph 537 identified the need for there to be a rational, logical, or defensible connection to the shared goals, expectations, and understandings of the parties. And the Court of Appeal, as we've already touched upon at paragraph 323, emphasized the importance of taking into account the Anishinaabe principles of respect, responsibility, renewal, and reciprocity. Professor Mintz and Mr. O'Riordan as well agreed that rents were a measure of the value of the treaty territory. And you can see our main argument on this at para 329 and footnote 209, which we corrected this morning. But neither of them sought to estimate what those rents were. They just argued that using rents in this case was wrong. It will be recalled that Professor Mintz agreed with the plaintiff's experts that logging tax was a revenue source. Mr. Fred O'Riordan, economist, testified for Canada. Mr. O'Riordan testified regarding the approaches to compensation, the conventional approach, rents, limitations on the rent approach, sharing framework, and evaluating deprivation using concepts of relative wealth or income. Importantly, he viewed his task of considering approaches to past compensation through the lens of his instruction letter from Canada, which instructed him to assume that the compensation for the past would be based on direct revenues alone. Obviously, the work product he delivered was a function of his instructions. And I've given myself a footnote here to, if you have a question, see transcript page 3220. He agreed that his report doesn't consider or discuss the lost opportunity to engage in a process. My impression overall is that Mr. O'Riordan took a Crown-centric narrow view to the treaty, a narrow view to the relationship between the Crown and the Anishinaabe, and a narrow view of the obligations under the treaty. Missing as well from his opinion is that important, rational, logical, or defensible connection to the shared goals and expectations and understandings, and a connection to the Anishinaabe principles that animated the treaty. The next witness was Professor Eric Kersner, an economist. Professor Kersner was tasked with analyzing excerpts of the band trust accounts of some of the First Nations to identify the spending patterns of some of the bands for the purpose of implementing what has been come to know the Booth-Kersner model to bring forward amounts. In this case, it would be to bring forward the direct NCRRs to 2019. Professor Kersner admitted that the Booth-Kersner model came into existence while he was working on a case for the government of Canada, and that's a transcript page 3546 to 3547, and that he made decisions regarding what data to include in his report, which obviously influenced his conclusions, based on what Canada instructed for him to do, because in his words, and I'm using his words, Canada is paying the bill. He agreed, incidentally, that 60% equity in a mixed portfolio is a suitable approach. So he actually agreed that the 60-40 approach was reasonable. And that's at transcript page 3619, lines 20 to 24. Overall, it was apparent from his testimony that he was wholly unfamiliar with the data set he used in his report. And he relied heavily on the work of Ernst & Young, who did not testify. He could not explain how Ernst & Young classified expenses or performed most of their data entry, or whether they even had the data from the capital accounts. We later learned in cross-examination, they did have the data on the capital accounts, but they chose not to use them. In his analysis of the spending and saving in the trust accounts, he did not include the RST bands of Red Rock, White Sand, AZA, or Michipicoten, and he could not remember how he chose the bands that were chosen. And in fact, most bands that were chosen were Huron bands. Respectfully, there's no basis to accept that the sample was a representative sample worthy of the court's attention. He also admitted to not considering the Court of Appeal's guidance. His work made no reference to the Court of Appeal reasons and only one reference to the amended Stage 1 judgment. Overall, Professor Kersner had, in my view, an outdated view of the treaty and the relationship between the Crown and the Robinson Superior Anishinaabe. My impression was that he was regularly confused when discussing the data, appeared to be guessing a fair bit of the time, or said that he didn't know when he was asked questions about the data set that he relied on for his results and which he should have had a better command of. Now, as kindly as this witness was, and I think he was kind, his data and conclusions are unreliable, and his conclusions are inconsistent with what the data that was collected actually shows. The Booth-Kersner bring forward model is unworkable, complex, morally bankrupt, and has been rejected by the courts. It should be rejected in this court as well. Professor Lawrence Booth, also an economist. Professor Booth was responsible for explaining the conceptual background to the Booth-Kersner approach, discussing that's Booth and Kersner's economic interpretation of the augmentation clause and rates of return, and risk and depreciation. Respectfully, my view is that the tone of his evidence was not as an independent witness per se to help the court, but as an advocate for the Booth-Kersner model. His testimony was marked by the palpable feeling that it was important for him to prove that he was the smartest person in the room. There's no kind way to say that, that's my impression. His demeanor was such that he had an air of superiority about him, and he was unnecessarily combative and unhelpful. My view is that he was defensive when discussing the choice to only look at the revenue accounts for their analysis, and he was equivocal about looking at the spending and saving patterns in the capital account. My impression was that he was relatively cavalier in his testimony. At times, he was defensive, at times argumentative, and at times unresponsive, and at times unhelpful. His testimony should leave the court with many questions about the validity of the Booth-Kersner approach to bring forward amounts, even if they had been working with the correct data. Professor Barbara Mesimore, historian. Professor Mesimore testified to the arrangements made at the time of Confederation for debts and liabilities in the post-Confederation arbitrations between Ontario, Quebec, and the Dominion of Canada. My impression is she testified with candor and was reliable in her opinions. Turning then to Ontario's experts. Dr. Von Gernot, ethnohistorian. Dr. Von Gernot testified to his interpretation of the historical documents he read regarding the Crown's efforts to make annuity payments since 1850. I might say, in my view, while polite in the delivery of his evidence, Dr. Von Gernot seemed, in my opinion, to have an agenda to make sure the court knew that, in his opinion, the courts had got it wrong in stage one. His opinions were based on his review of the documents alone, without any real-world interaction with the Anishinaabe to permit him to better understand what the documents revealed about the intentions and understandings of the parties. Dr. Von Gernot inferred from the documents and then expressed those inferences as fact about what happened and the intention of the parties in a manner inconsistent with stage one and the Court of Appeal reasons and judgment. While professing to opine on the Anishinaabe perspective, respectfully, there was nothing in Dr. Von Gernot's reports or in his testimony that genuinely took into account any Aboriginal perspectives. We say that it is a fair criticism that Dr. Von Gernot's approach to the historical documents was actually to ignore the Anishinaabe perspective, discount what was actually written for them when what was written for them is inconsistent with his views. And then he preferred and accepted, without any critical consideration, what Crown actors wrote, where Crown actors, he cited, agreed with his opinion. In my view, he interpreted what Crown actors wrote only in a manner that supported his chosen, and I might say rejected, theories, including the theory that the Anishinaabe wanted a fixed $10 per capita annuity as opposed to a share of the future proceeds. Also, that the bargain reached was limited to $4 per capita, and that the Anishinaabe were only ever asking for increases to $4 per capita. Ontario characterized in their argument Dr. Von Gernot's report and work as yeoman's work. Now, that's Ontario's reply, paragraph 84. I wasn't quite sure what a yeoman's work is, so I actually had to look it up. So I went to the Merriam-Webster dictionary, where it's defined as very good, hard, and valuable work that someone does to support a cause and to help a team. Well, that's the definition of an advocate. And if that is indeed what they meant by yeoman's work, I must agree. And that is exactly how Dr. Von Gernert presented in court as an advocate for a cause, Ontario's cause. Overall, his evidence was not reliable, and I submit was off base and can be described as unhelpful with more than a ring of advocacy to it. I respectfully suggest his evidence should be given little or no weight in this stage 3. Missing from his opinion was any rational, logical, or defensible connection to the shared goals, expectations, and understandings of the parties and the Anishinaabe principles that animated the treaty. Mr. Cliff Hamal, an electricity expert. Mr. Hamal spent a large part of his testimony making small and relatively insignificant criticisms of Mr. Hutchings' calculations of hydro net crown resource revenues. And then he concluded that Hutchings' opinions and conclusions were not unreasonable, which is to say, reasonable conclusions. His evidence on the direct net revenues captured by the Crown was unnecessary, as he agreed with the results put forward by Hutchings. Mr. Hamal, or Hamill, I think I may be pronouncing it, it's Hamill. Yeah, I apologize if he's watching. Mr. Hamill is not an economist, and throughout his reports and in his testimony gave multiple conflicting interpretation of economic rents. His evidence on rents can be characterized as inconsistent, confusing, and argumentative. His evidence should not be preferred to that of Stiglitz and Hutchings on any area of disagreement. The next witness Ontario brought was Professor Michael Smart, an economist. Professor Smart gave evidence on calculating net crown resource revenues, interest rates, and bring forwards theory calculations and sharing. He had many critiques of Stiglitz and Hutchings. My overall impression is he did not present well on cross-examinations and that his opinions did not withstand scrutiny. Respectfully, like Professor Kersner, Professor Smart came across as an advocate for the client paying the bill. My impression was among all the witnesses, Professor Smart stood out as being particularly evasive, hostile, and uncooperative. He was argumentative, unyielding, unreasonable, and combative throughout his testimony. I think it would be beyond generous to attribute his demeanor and tone to this being the first time that he is testifying. In fact, it's hard to conceive of his opinions as being the product of an independent mind seeking to assist the court. He was not, at the end of the day, a credible witness, and his opinions were not reliable. The error rate he admitted to, going as it was from -7 billion to -4.5 billion, was significant. Missing from the theories advanced by Bodway and Smart, most notably their risk-adjusted one-time non-relational 1850 purchase approach, their assumptions of perfect foresight in 1850, and their smoothing out, I guess they call it the Bodway and Smart annuity approach now, used to be called Vidal and Anderson approach in their reports, and their bring forward calculations based on bond rates do not have a rational connection or defensible connection to the goals, expectations, and understandings of the parties in 1850 or any time thereafter, nor the Anishinaabe principles that animated the treaty. missing as well is a connection to what could have and would have happened. There, Bodway and Smart's theories about what might have happened are just inconsistent with the evidence. In reviewing Mr. Smart's evidence, the court must be mindful that when he sought to demonstrate the consequences of what he claimed, incorrectly we say, were errors in the plaintiff's calculations, he presented his data on a province-wide basis, making it appear that the consequences for the end result were dramatic, when in fact they were of little import, even if his opinion was accepted. I just want to pause here. The court might remember all of Mr. Smart's, Professor Smart's slide deck used province-wide numbers, but there was a prime example of making a small difference seem like a big one by the way Professor Smart reported on the discrepancy in mining profits tax for 1935. That came up in the evidence at pages 6905 to 6913. Recall that Professor Smart testified in respect of his slide deck, page 38, exhibit 70, that at 60 forward bring forward rates, the alleged error made by Mr. Hutchins was valued at over $500 million. But that was based on a province-wide number, and the actual number in dispute brought forward to 2021 was 0.2% of that amount. That is truly a mountain made out of a molehill.
I might be missing what you're saying, and possibly I don't have perfect recall. You say he based his data on province-wide numbers.
That's right.
But that the difference between the province-wide numbers and, I presume, the territory numbers was minuscule.
That's right. You might remember.
So what are you pointing out to? That there was an error?
Yeah. What the court should be mindful of is that when you look through his slide deck and his testimony,
Yes.
he makes it appear that small errors or small differences are of a big magnitude, and made a mountain out of a molehill by saying, here I've, in effect, saying, look at this, on the mining profits tax for 1935, I have caught Mr. Hutchins in an error that's worth $500 million. But when we drilled down to it in cross-examination, it wasn't a half, even if he's right, you know, Mr. Hutchins had a defense to that, but even if he's right, it's not a $500 million error for the judge to consider. It's 0.2% of that. That's a far different thing. And to suggest that Mr. Hutchins made a $500 million error when it's a 0.2% of $500 million is completely a different thing. So that's the point I was trying to make.
Thank you.
The Bodway and Smart analysis should be rejected, including the use of expenses that support resource rents instead of expenses that support relevant resource revenues. Mr. Smart's evidence in particular should be approached with caution, befitting the manner in which he testified. That brings us to Professor Robin Bodway, an economist. Professor Bodway was called to critique the Stiglitz and Hutchins approach to rents and sharing, and co-authored his reports with Professor Smart. I must say that Professor Bodway was polite, collegial, kind, affable, and there was nothing in his demeanor that I could see to suggest his opinion should be rejected on that basis. In short, I found Professor Bodway presented credibly. But Ultimately, cross-examination revealed that on the points where he disagreed with Stiglitz and Hutching, which is on the Bodway and Smart theories, his evidence and the calculations made were simply not reliable. My recollection is that during cross-examination, Professor Bodway expressed that he did not disagree with significant elements of what Professor Stiglitz and Mr. Hutchings opined on. Professor Bodway's opinions, like Professor Smart's, were founded on assumptions not in evidence, including his reliance upon Dr. von Gernot. His whole methodology of treating the bargain as a one-time purchase and the use of perfect foresight in 1850 are assumptions inconsistent with the facts. Likewise, the renamed Smart Bodway approach to annuities is inconsistent with the facts in the bargain reached and is built on a misunderstanding of what Mr. Vidal and Anderson said in 1849. I think I can fairly say this of Professor Bodway, he was honest but imprecise, and he deferred significantly to Professor Smart on the parts of their joint report where calculations were needed. His testimony was punctuated and notable for a number of memory lapses. On cross-examination, he agreed with Stiglitz and Hutchings on a number of important variables. For example, he admitted to the relevancy of resource rents, all but conceded that the approach he used in ignoring housing for income gap approach was a mistake. And you will recall that he suggested that the optimal rents that could possibly be extracted is the most accurate measure of the value of the treaty territory. Although he said it would be difficult to measure, but if you really wanted to measure the value of the treaty territory, you would not measure what Stiglitz and Hutchings did, which is the actual resource rents. You would instead look at the optimal resource rents. At the end of the day, Professor Bodway was credible, but his opinions and the results that he and Professor Smart arrived at were unreliable, unbelievable, and with respect, defied the application of common sense. Dr. Kenneth Coates, historian. Dr. Coates testified about the motivations for Confederation and the understanding of Crown actors after Confederation with respect to sections 111, 112, and 142. He came across just fine, did not seem to have any issue of dispute with the plaintiff's position. And I might add, my recollection of his evidence was on the one issue where I think it matters for the plaintiffs, he did not opine that Ontario only came into existence in 1867. He treated it as a union of entities within Confederation. But we'll get to that more in the argument. Mr. Eric Angel, historian. Mr. Angel testified about the Indian Trust Fund accounts, also came to be referred to as the band trust accounts, how they operated, and how the specific superior trust funds were operated in the few instances in the limited temporal window he considered up to 1909, where the superior bands had money held for them in the band trust accounts. Now, we observed in the cross-examination that Mr. Angel allowed the Crown lawyer to at least direct the content of parts of his report. A case could be made that there was some joint authorship taking place. And this would and should negatively affect the weight to be given to his report generally. However, I observed that Mr. Angel's evidence was largely uncontroversial. It focused on how money was invested in the band trust accounts, and I found his evidence on that score to be generally helpful. However, the one controversial area of his report was his claim that annuity monies were Indian monies. And if they're Indian monies, as a matter of law, they would have to be invested by the Crown at band trust account rates. On cross-examination, he came right out and admitted that he does not have the expertise to opine on that very issue. He was credible, and his collection of documents were reliable and readable, quite frankly, without his report. I saw his evidence really serving as a helpful summary of what many, many historical documents recorded. So to that extent, I think we owe him some gratitude. I thought he was helpful for that. Ms. Gwyneth Jones, historian. The focus of Ms. Jones' report and opinions was on the relationships between Canada, Ontario, the province of Canada, and Quebec. The Superior Anishinaabe were truly at the margins of her report. Most of her report was interesting, ultimately irrelevant to the issues of concern to the plaintiffs. And as usual, Ms. Jones was attempted to be very precise in her testimony and preferred the written documents as opposed to the transcribed ones. And I really don't have anything much more to say right now about Ms. Jones. And we are now at 10-3. I think I can get on to the next topic unless the court has any questions at all on on this.
I just have one question, which I had during the evidence of, is it Mr. Angel, Dr. Angel? If Indian monies, then as a matter of law, they would have to be invested in BTA. Is there a place I go to have a definition of Indian monies or that proposition of law? Or do we, is that important?
That I can help the court with that. That proposition of law comes, I believe, from the Erminskin case from 2009. I'm just going from memory. I don't have a citation for you. Ms. Lewis, I'll bet, is looking it up right now. But the Supreme Court of Canada in that case said, even though there's a fiduciary duty, if the money is Indian monies, it must, as a matter of law, be invested in the band trust accounts. So that's where that principle comes from. As for a definition of Indian monies, I don't think you will find a proper definition. A number of cases have discussed it, but I don't believe there's a clear definition of what Indian monies are. You can look in the Indian Act for that, but there are important facts in this particular case that the court should be mindful of on that very point. And that is, none of the parties in this court case are claiming that the annuity monies are Indian monies.
Okay, thank you.
Oh, I was right on Erminskin 2009 SCC 9.
Thank you.
So I was just saying that none of the parties claim it's Indian monies. All of the parties are arguing, or at least the Crowns are certainly arguing, that the Anishinaabe could not have put the money in the band trust accounts.
Right.
And the plaintiffs accept that as well. We say the money would have gone to the chiefs and councils. It had to have gone to the chiefs and councils because that is the body that represents the collective.
And so when you say none of the parties now are claiming that they were Indian monies, are claiming that annuities were Indian monies?
That's correct.
Thank you.
And I might be even clearer, not only are the parties now not claiming it, I don't believe the evidence historically suggests that any annuities were ever considered Indian monies. Monies in annuities were dispersed in the year in which they were payable, save for some refunds, I believe, or when people didn't show up to capture it.
So
But-
what is an example of Indian monies? The sale of reserve land?
Yeah,
Sale of
yes.
properties?
Yes. So Indian monies would be basically the revenue account or the capital account. So for example, if an Indian band surrendered a part of its reserve, the monies would be Indian monies that would go into the band trust, be invested at the band trust account rates. And that's where, for example, you have the fiduciary duty attaching to the surrender of Indian monies.
And those were often called proceeds of something, proceeds of sales or proceeds of
Well,
rental agreement, something done on behalf.
that's right. And another way that Indian monies come into existence is like in the Erminskin case, oil and gas revenues,
Right.
right? So you have oil and gas coming from the reserve. It is Indian monies by definition, and the Erminskin case said, well, sorry, you might have wanted these to be invested better than at band trust rates, but there's a statutory impediment to doing that. And what is interesting, I don't know what the evidence was in Erminskin about the appropriateness or not of the fiduciary investing in alternate investments. I simply don't know, and it needn't trouble us here because, of course, the monies aren't Indian monies.
Thank you.
I want to recall some historical facts, and I think I maybe have time to deal with this before we have a break. So the reason why I wanted to touch a little bit about history is because I want to sort of set the stage for the court to remember, and as much as I'm sure the court does remember all of this, I'm not going to take a huge amount of the court's time on this, but I'm going to give a general overview. So we start with the Anishinaabe wanting to share the wealth into the future prior to the treaty. The court will remember that the Anishinaabe wanted pay for every pound. One of the chiefs said, I want to stay and get my share. The court will remember that Vidal and Anderson made clear that the Crown in 1849 was prepared to share any new source of wealth. No one knew in 1850 what the future would hold, is another fact. The treaty was negotiated using Anishinaabe concepts of kinship and principles of respect, responsibility, renewal, and reciprocity were at the heart of the treaty bargain. The parties, not knowing what the future would hold, were content to take a wait and see approach. This is all part of stage one judgment. The parties met in council and a $10 starting salary was not agreed to. A fixed $10 annuity was not agreed to. A fixed $10 annuity was not even necessarily asked. What we know, what was agreed to was what I would call a starting salary of pound 500 or $2,000 a year. We also know from the facts that the annuity was a collective entitlement, and the reference to $4 was not any cap on the collective entitlement at all. It was a soft cap on that part of the collective annuity that would be distributed to individuals. The court will remember the evidence that shortly after the treaty was made, one Huron chief, Shingwakons, was so displeased about the amount he was to receive under the annuity that he was planning to go visit the Queen to have it changed. But through Colonel Bruce, Robinson assured Shingwakons that there were prospective advantages coming in the future that were fair and just. We don't know exactly what was communicated, but we do know that Shingwakons did not go to visit the Queen, and he died a few years later. In 1852, the Fort William First Nation, together with other nations around the lake, Lake Nipigon, seeing how small their annuity entitlement was in 1851, caused a petition of grievance to be sent to the Governor General. They complained that all the benefits of the treaty they were supposed to be seeing were not seen. There is no response to that petition. A few years later, in 1858, the Commissioner of Crown Lands, Mr. Carney, observed that it was unfair to give away the lands without properly taking the full fair market value of the lands into consideration for the purposes of identifying an augmentation entitlement. His inquiry of Pennyfather does not seem to have resulted in any consideration of his proposal. A proposal which I think I mentioned earlier today is very much consistent with the rent-based approach considered by Stiglitz. In 1969, some Huron chiefs repeated their concerns about land being given away to their detriment in a petition, and once again, there was no response. In 1873, after receiving a further petition from Fort William, Member of Parliament Simon Dawson put forward a request.
You said in 1969, was that?
1869, thank you very much. My apologies.
I thought we had jumped ahead.
No, haven't jumped yet. I even wrote 1969, okay. At least I can read.
Small mercies.
Yeah, exactly. All right, in 1873, after receiving a further petition from Fort William, Member of Parliament Simon Dawson put forward a request to the government for such increase as they might be entitled to. You might remember that Mr. Dawson did not think that they were limited to $4 and they might be entitled to even more. Shortly after receiving that request, Sprague, on behalf of Canada, decided on his own accord to forward a request for an increase to the province. But instead of asking for an increase as may be allowed for under the treaty, Sprague unilaterally changed the request to one seeking an increase, quote unquote, to the extent of $4 per capita. We know that in 1874, 1 year later, when no answer was forthcoming to Fort William, the Fort William Anishinaabe submitted yet another petition and again sought an increase as the treaty might allow. That request was never responded to. Between 1875 and 1900, the crowns fought between themselves as to which of them was liable to indemnify the other for the $4 augmented annuity and the issue of arrears. During that time, various requests were made by the Anishinaabe for further increases, but none were ever answered. One Crown official, I believe it was in 1893, thought it was time to inquire whether it was now time for a further increase. You might remember Von Kunit was his name. We learned in stage 3 that his reward was the unemployment line. Ontario, whether there was any connection or not to his advocating for Aboriginal people or not, it was not demonstrated. It was perhaps coincidence, perhaps not. It's an open question. Ontario and Canada conveniently agreed in 1900 they need not inquire further as between themselves, and by 1903 the matter was at an end, with the Anishinaabe simply forgotten. And so, ignored and marginalized, the Anishinaabe concerns have awaited 2023 for vindication. This would be a good time for a break.
Let me just catch up, please. Thank you. We'll take a break, 15 minutes.
Minutes?
We're all right.
Can I talk to you? Yeah, follow me.
This court is stood down for 15 minutes.